script to adjust. That might be completely illegal, and you might be owed everything they withheld. Ever wonder if the label on your contract actually holds up in court? Today I'll explain worker misclassification like you're 5 years old. By the end, you'll know the exact legal test used to prove it, what you may be owed, and the one move your employer is hoping you never make. Quick note before we go. This is legal education, not legal advice. Laws vary by state and situation, so if this sounds like your life, talk to an employment attorney. Many work on contingency, meaning they only get paid if you win. You got a job offer? Maybe freelance graphic design. Maybe driving a delivery route. Maybe it was answering phones at a staffing agency. The company says you're a contractor with no benefits, no overtime, and no health insurance. You sign the paperwork because you need the income, and you assume they know the rules. And then, 3 months in, a friend doing the exact same job mentions their employer matches their 401k. They also get 2 weeks of paid time off. Same work, completely different deal. They get sick days too. And if they get hurt on the job, workers' comp has them covered. And you start to wonder, wait, can they actually do that? Here's what your employer is counting on, that you won't know the answer to that question. Here's the thing, calling someone a contractor doesn't actually make them a contractor. Your employer doesn't get to decide your legal status, the law does. And the law has a very specific checklist to figure out the truth. Think of it like sticking a Starbucks label on a gas station coffee cup. You can write it in marker and say it with total confidence, but eventually someone takes a sip and the whole story falls apart. So what's on that checklist? At the federal level, it's called the economic reality test. The law asks one big question. Are you running your own independent business, or are you economically dependent on this one company? If you truly run your own business, you set your own prices and work for multiple clients, then contractor might actually fit. If you also decide how and when the work gets done and bring your own tools, the label may hold up. But if you show up when they tell you to, wear their uniform, follow their process, and use their equipment, that's an employee, even if the contract says otherwise. The label doesn't control the reality, and that distinction is exactly where these cases are won. Now here's the part where this gets really interesting. You need to understand what your employer was actually doing when they made that call, because this was not a mistake. Picture it, a Tuesday afternoon in some HR conference room, and someone ran a spreadsheet. Full-time employee with benefits, overtime protection, payroll taxes, and workers' comp. That adds roughly 30% on top of your salary. Contractor, they write you a check and that's it. No taxes, no benefits, no liability. Same amount of work, dramatically lower bill. Their legal team has a word for workers who never question the label. They call them easy. And here's the number that will make your jaw drop. The Department of Labor estimates that misclassification costs workers billions of dollars every year in unpaid wages and benefits. Not millions, billions. And that number doesn't even account for the long-term hits. Lower Social Security credits, no employer-matched retirement contributions, no unemployment insurance if things go sideways. This isn't confusion. This is a business model, built on your silence. But wait. Here's the counterintuitive part, the part your employer definitely did not put in the onboarding packet. If they misclassified you, you may be owed back pay for every dollar of overtime they didn't pay. You may be owed your share of payroll taxes they quietly skipped. In some states, you can recover penalties on top of everything else. And under the Fair Labor Standards Act, the look-back period can stretch up to 3 years if the violation was willful. Meaning, the longer this has been going on, the larger the potential recovery. But here's the move that changes the whole board. Under the Fair Labor Standards Act, once you raise a misclassification claim, it's on your employer to prove you really were a contractor, not on you to prove you weren't. They made the call. They have to defend it. You just have to raise your hand. Now let's talk about the IRS, because they have their own test, completely separate from the Department of Labor. It's called the Common Law Test, and it looks at 20 factors. You don't need to memorize all 20. But here are 3 that surprise people every time. First, did the company train you on how to do the job? Real contractors already know how. If they trained you, that's an employee signal. Second, did you work exclusively for them for an extended period? Real contractors have multiple clients. One company, long-term, looks like employment. Third, did they provide the tools and workspace? Your own tools, your own setup. That's independent. Their laptop, their desk, their login, their building badge, that's employment. The IRS looks at the total picture, and the total picture has a way of looking very different from the contract you signed. Here's something else most people don't know. The law varies significantly by state, and in some states, your employer's burden is even heavier than at the federal level. California uses something called the ABC test. Under that test, a company has to prove 3 specific things to legally call you a contractor. 1. You're free from their control. 2. You do work that's genuinely outside their normal business. 3. You have an independently established trade or business. That second prong is brutal for a lot of companies. If you drive for a delivery company and they say you're a contractor, they have to prove that delivery work is outside their normal business. A delivery company claiming delivery isn't their core business. Completely legal argument. Also completely impossible to make with a straight face. California workers have won significant cases on exactly this. Other states like New Jersey, Massachusetts, and Illinois are moving in the same direction with similarly worker-friendly standards. So let's go back to your situation. Same desk, same hours, same manager telling you what to wear and when to show up. But now you're seeing it differently. Here's what you actually do. Step 1. Look at your work situation honestly and compare it to the test. Do you set your own hours? Do you work for other clients? Do you bring your own equipment? Do you have a real chance to make more profit by working smarter? Or is your pay fixed no matter what? If most of those answers are no, you are probably an employee. Write it down. Document everything. Texts, emails, schedules, instructions from your manager. Every time they told you what to do and how to do it is evidence. Step 2. File a complaint. For free. The Department of Labor's Wage and Hour Division takes misclassification complaints. So does the IRS. Many state labor boards have their own processes that move faster than federal ones. You don't need a lawyer to file. You need your information and a few hours. Step 3. Talk to an employment attorney. Most offer free consultations. Many take these cases on contingency. They only get paid if you recover money. They have every incentive to be honest with you about whether you have a case. One conversation could be worth 3 years of unpaid overtime. Here's the clip-worthy truth of all of this. Your employer didn't call you a contractor because it was accurate. They called you a contractor because it was cheaper. The label saved them real money every single week. And every single week, you didn't question it. You absorbed the full cost of their decision. That's not a gray area. That's a strategy built on your silence. Now picture walking back into that job. Same desk, same manager, same hours. But now you know the legal clock may already be running in your favor. The law doesn't care what your contract says. It cares what actually happened. And what actually happened, you were there for every single bit of it. Drop a comment right now. How did your employer describe your status when you got hired? And did anything in this video just click into place? Because I have a feeling the comments on this one are going to tell a whole story on their own.